Greetings and welcome to Law of Evidence, Definitions and Principles from American Jurisprudence. Let's get started where we left off last time. And that was on Section 16, the determination of preliminary questions of facts. Again, we're reviewing essentially the federal rules of evidence and as they would apply in other settings, as many states also they model their rules of evidence after federal rules, but the most strict usually in practically all circumstances would be the federal rules of evidence. So this is what we're using as our standard. And with that said, just keep in mind that this is strictly for the entertainment educational purposes of the YouTube broadcast, not to be used, misconstrued, or mispurposed for your personal, professional, legal, lawful, business, or tax purposes. Please don't do this at home. Let's get started. The federal rules of evidence, other than those with respect to privileges, do not apply to the determination of questions of facts preliminarily to the admissibility of evidence when the issue to be determined by the court under Federal Rules of Evidence 104 and Federal Rules of Evidence 1101D1 confirms a general view of various authorities on evidence that the rules of evidence governing criminal jury trials do not govern hearings before a judge to determine evidentiary questions. So I think we're getting into the evidentiary hearings here, essentially. In accordance with the federal rules of evidence, the federal rules of evidence are not applicable to suppression hearings, and therefore the admission of hearsay evidence and evidence without formal authentication is permissible at such hearings, although the court remains obligated to weigh the evidence and discount that which is less reliable. So it seems that there's suppression hearings and such where you could hear things that might not be strictly to the rules of evidence, but in documents it seems without formal authentication. But this is always just to weigh the evidence and discount that which is less reliable to then be admitted. However, the rule governing rules on evidence has been held applicable to a separate hearing to determine the voluntariness of a confession, and thus a claim on appeal that the court improperly excluded evidence in such a hearing, which error is not properly preserved by an offer of proof as required by the rule, is not permitted. So let's break this down here. The rule governing rulings on evidence, rule refers to the federal rules of evidence. The rule governing rulings on evidence has been held applicable to a separate hearing to determine the voluntariness of a confession. So the rules, the evidence used to determine the voluntariness of a confession is to be held under the rules of evidence, it seems, because a claim on appeal, the court improperly excluded evidence on such a hearing which error is not properly preserved by an offer of proof as required. So that was the instance in the case there. It's not permitted. So here's an observation. The advisory committee notes the federal rules of evidence say that Federal Rules of Evidence 1101D1 restates, for convenience, the provisions of the second sentence of the Federal Rules of Evidence 104A. However, one court said that the advisory committee notes on the Federal Rules of Evidence are in error in this regard, since the second sentence of the Federal Rules of Evidence provides that in making its determination, the court is not bound by the rules of evidence except those with respect to privileges. And the words not bound have an entirely different and much narrower purport than the flat statement that the rules do not apply. Not bound by the rules, but it's different than they do not apply. So, in the details here, according to this court, the words not bound simply mean that the court may generally apply the rules unless for some reason they should not be applied, Whereas the term not applicable, meaning that do not apply, means what it says, that the rules do not apply. Good observation there. Hey, from Matlock, United States versus Matlock. That's a good attorney. One court has concluded that since the federal rules of evidence do not apply to suppression hearings by reason of federal rules of evidence 1101d1, the common law of evidence interpreted in the light of reason and experience. Remember we talked about this, a common law of evidence interpreted in the light of reason and experience applies to such hearings. So as you notice here, even in the federal rules of evidence, how we keep coming back to the common law, as is our tradition here on America. Section 17, grand jury proceedings. The federal rules of evidence, other than with respect to privileges, do not apply in proceedings before grand juries. The grand jury may compel the production of evidence or the testimony of witnesses as it considers appropriate, and its operation generally is unrestrained by technical, procedural, and evidentiary rules governing conduct of criminal trials. Wow. So a grand jury may compel production of evidence or testimony it considers appropriate and unrestrained by technical, procedural, and evidentiary rules. Thus, the rule dealing with compromise and offers to compromise does not apply in the first instance in grand jury proceedings, and does not apply by analogy in such proceedings, since the grand jury cannot be hamstrung in its essential function to uncover matters which may relate to potential criminal acts. However, under rules of evidence, constitutional or otherwise, are generally inapplicable to grand jury proceedings. Evidentiary rules may illuminate the factors mitigating prejudice, and consequently, when prejudicial matters cannot be excised, when probative value exceeds prejudicial effects, or when less prejudicial evidence is unavailable, the prejudice may be ignored. Oh, Lord. So we're trying to eliminate the factors mitigating prejudice. So we're trying to limit prejudice. Consequently, when prejudicial matters cannot be excised, when probative value exceeds prejudicial effects, or when less prejudicial evidence is unavailable, the prejudice may be ignored. So if you have no other evidence, then a little bit of prejudice is better than nothing, it seems, when it comes to evidence. Although Federal Rules of Evidence 1101D provides that the rules of evidence do not apply to proceedings before grand juries, this rule specifically accepts the Federal Rules of Evidence governing privileges, and thus attorney-client privilege does not apply to grand jury proceedings. A grand jury witness may thus resist questioning or a subpoena on the grounds that it calls for the production of attorney work product. Wow. Federal Rules of Evidence 1101D2 does not deal with the evidence required to support an indictment. So look at this. A grand jury witness may thus resist questioning or a subpoena on the grounds that it calls for the production of attorney work product. All right, let's pop over here to the chat real quick, see who we have in here. Hey, we have El Perro. Welcome. Yeah, we're going to be getting into the details of the rules a little bit later. We're getting some backgrounds here with American jurisprudence first to ensure the rules will make sense when we read them. They'll be a little bit more familiar because we've seen them now as they apply. So we have some interesting footnotes here. Federal Rules of Evidence does not deal with the evidence required to support an indictment. Interesting. Supporting indictments does not have to apply. So we're looking really at trial settings when we're speaking about the Federal Rules of Evidence. Comment on the footnotes here. This subdivision of Federal Rules of Evidence 1101 accords with the Supreme Court decision of Costello versus United States, in which the court refused to allow an indictment to be attacked for either constitutional or policy reasons on the ground that only hearsay evidence was presented. So this is interesting. refuse to allow an indictment to be attacked because only on the grounds that only hearsay evidence was presented. So that's interesting there, that indictments can be done by hearsay, it seems, hearsay evidence. As to the nature and functions of grand juries generally, for discussion of protection against discovery of attorney work product, depositions and discovery. So this is an interesting AmJur too. We might have to look at this at some time in the future. Other proceedings, Section 18. The federal rules of evidence, other than those with respect to privileges, do not apply to various miscellaneous proceedings, including, so here's some of the, with respect to privileges now, other than those with respect to privileges, do not apply to various miscellaneous proceedings. So here's where the federal rules of evidence do not apply. Proceedings for extradition or rendition. Preliminary examinations in criminal cases, as we read. The sentencing, granting, or revoking of probation. The issuance of warrants for arrest, criminal summonses, and search warrants. So these do not apply. Proceedings with respect to release on bail or otherwise. Again, federal rules of evidence do not apply. So here's where you get, it says other than those with respect to privileges. So hearsay and such would still apply, it seems. Extradition and rendition proceedings are governed in detail by statute and are essentially administrative in character, and traditionally, rules of evidence have not been applied in such proceedings. In preliminary examinations in criminal cases, hearsay testimony is customarily received, and according to the advisory committee, it is believed that the extent of the applicability of the rules of evidence to preliminary examinations should be appropriately dealt with by the federal rules of criminal procedure, which regulate those proceedings. So here they're saying that these preliminary examinations should be dealt with the federal rules of criminal procedures, not the federal rules of evidence. Rules of evidence have not been regarded as applicable to sentencing or probation proceedings, where great reliance is placed on the pre-sentence investigation and report. And again, the pre-sentence investigation and report. As regards sentencing, Federal Rules of Evidence 1101D3 largely parallels a federal criminal statute governing use of information at sentencing, wherein Congress declared that no limitation could be placed on the information concerning the background, character, and conduct of a person convicted of an offense which a court of the United States may receive and consider for the purpose of imposing an appropriate sentence. Thus, any exclusion of evidence at a sentencing proceeding must be based not merely upon the hearsay nature of the evidence, for example, but on the due process or confrontation clause implications of the evidence. So take note. Any exclusion of evidence at sentencing proceedings, so if there's some bad information that's going to be used at a sentencing and it is needed to be excluded, let's say, it can't be based merely upon the hearsay nature of that evidence, supposed evidence, right? But on the due process or confrontation clause implications of the evidence. So that's the focus, to try to exclude certain evidence. Similarly, a probation revocation hearing is not a formal trial, and the Federal Rules of Evidence provides that Federal Rules of Evidence, other than those with respect to privileges, do not apply in proceedings for revoking probation. So right there in 1101D3 specifically. Warrants for arrest, criminal summonses, and search warrants are issued upon complaint or affidavit showing probable cause, and the nature of the proceedings makes application of the formal rules of evidence inappropriate and impracticable. Proceedings with respect to release on bail or otherwise do not call for application of the Federal Rules of Evidence, since the governing statute specifically provides that the rules pertaining to the admissibility of evidence in criminal trials do not apply to the presentation and consideration of information at a detention hearing. The reference to the weight of the evidence against the accused in the statute as a factor to be considered in determining the conditions of a pretrial release of a person charged with an offense clearly does not have in view evidence introduced at a hearing under the federal rules of evidence. So again, let's see here. What was it? The reference to the weight of evidence against the accused in the statute as a factor to be considered in determining the conditions of a pretrial release does not have in view evidence introduced at a hearing under federal rules of evidence. In addition, the proceedings specified in the Federal Rules of Evidence 1101D3, the Federal Rules of Evidence are inapplicable to, so here's where they do not apply, a contempt proceeding in which the court may act summarily. Another one where they're inapplicable to a hearing on such preliminary matters as class certification, when a full-scale evidentiary hearing may not be absolutely necessary. Here's another situation here where it would not be applicable, the Federal Rules of Evidence. A proceeding conducted upon a motion to transfer a juvenile delinquency proceeding to adult court under the Federal Juvenile Delinquency Act. Oh, wow. It doesn't apply to parole board proceedings or rescission of status proceeding conducted by an immigration judge. Interesting. All right, let's get over here. Before we get to the supplement, let's get on to the chat here. Let me refresh this and make sure we're all fresh on the chat. Indeed. Here we go. And welcome, Bill Thomas. It says that the rules to mitigate mitigating factors starts feeling a bit meta. Yeah, well, the rules of the capital R I probably should mention too, if you're not looking at the text, because when they say rules with capital R, they're referring to the rules of the federal rules of evidence. And then rule with the lowercase r is referring to particular rules within that body of work there. And Awareness Daily, welcome. Who is the man between Bruce Wayne and Batman? You tell us. All right, let's proceed. Section 18, Other Proceedings, Supplement, Case Authorities. Rules of evidence do not apply to probation revocation proceedings. So hearsay is unobjectionable. Wow, so they come out with hearsay at a probation revocation proceeding, and you can't object to hearsay. District judge must use reliable evidence, but written reports of medical tests are generally reliable. Oh, Lord. 1995. So we're looking at a 1998, I think, supplement. So there are probably more current case holdings than we're reading here. However, we're reading about the federal rules of evidence, and these are pretty much well established. And if there's anything on the finer points, of course, you would have to look at the more current landscape of lawsuits to see where the holdings are. Here's the United States versus Charmer Industries. Appeal after remand. Evidence rules regarding hearsay are not applicable to sentencing proceedings. So a lot of hearsay, it seems, goes on with sentencing, probation, in federal cases. And as I said before, the federal rules of evidence are rather strict compared to state court rules. So I could kind of see why in certain situations to get the ball rolling, perhaps it is not always applicable. However, it's good to know where it is and where it's not. See, just here's some more of the cases. Criminal contempts are punishable summarily under federal criminal procedure if the judge certifies seeing or hearing the contempt in the presence of the court. Criminal contempt. So there's criminal contempt and civil contempt. United States Supreme Court has stated that a class action hearing of necessity is not accompanied by the traditional rules and procedures applicable to civil trials. Here, the evidence received in a juvenile delinquency hearing need not be measured by the standards of admissibility in a criminal trial. However, the evidence must measure up to the essentials of due process and fair treatment, since a hearing is a critically important action determining vitally important statutory rights of the juvenile. Oh, Lord. And then here we have a parole board hearing is not adversary proceeding and its purpose is not to determine whether a prisoner has committed a crime, but in light of facts and circumstances of case to determine whether a prisoner should be released from custody. And virtually all evidence considered in such proceedings must, of necessity, be hearsay. Oh boy. All right, before we get on to section 19, let's jump back over to the chat here. And El Perro says, that is when I entered 4 documents, straight facts, got 60 days instead of 2 years, like all previous 5 cases, same charge. Indeed, yeah, the facts are usually the best way to win. So, indeed. Let's continue. Section 19, proceedings to which rules are applicable in part in certain enumerated proceedings. The federal rules of evidence apply to the extent that matters of evidence are not provided for in the statutes which govern procedure in such proceedings or in other rules prescribed by the Supreme Court pursuant to statutory authority. In a substantial number of special proceedings, ad hoc evaluation has resulted in the promulgation of particularized evidentiary provisions by acts of Congress or by rules adopted by the Supreme Court. These provisions, which are well adapted to the particular proceedings, though not so adapted for inclusion in a set of general rules, are left undisturbed under Federal Rules of Evidence 1101E. Otherwise, the rules are applicable to the proceedings enumerated in the subdivision. Federal evidentiary rules generally govern in habeas corpus proceedings by reason of Federal Rules of Evidence 1101E. And there is nothing in the statutory provisions pertaining to habeas corpus or the Supreme Court rules governing such cases which would preclude the applicability of the rule, capital R rule, that's a rule of federal evidence, governing the competency of a juror to testify as a witness. Wow. Which provides in part that a juror's affidavit or evidence of any statement by a juror concerning a matter about which the juror would be precluded from testifying may not be received for purposes of an inquiry into the validity of a verdict or indictment. Wow. So a proceeding for challenging collaterally the validity of a federal conviction is a formal procedure with all the usual accoutrements of a civil trial, and the legal issues are determined under the established requirements of the Constitution, the statutes, that would be the statutes at large, and judicial precedents, while issues of fact are resolved under the Federal Rules of Evidence in view of the Federal Rules of Evidence 1101E, as El Perro was alluding to here, the straight facts. Let's continue. So now we're on to section 2 here, or title 2 here, the purpose and construction of the rules. All right, starting with section 20. Here's our introduction. Now this is construction of these rules. Hey, we have Jesse Howell from The Missing Link. Greetings and welcome. He's got a great show, the most shadow banned, open-minded interview show on YouTube, The Missing Link Live. So you need to, everyone needs to subscribe to that one. Let me try and pop it in here if I can real quick, because this is he's got so few people on his channel there. It's almost, it's heartbreaking when he has such a diverse group of people. He's got everything from the most elite scientists to fruitcakes. So there's no bias at all. And it's always a very open-ended, candid type of interview, which I really do appreciate. So I think all the audience here would appreciate too. Give me just a moment to pull up the Missing Link website here, or channel I should say, and post it here for all you guys to subscribe to. The Missing Link Live is the name of the channel. And give me just a moment here and get it over to our broadcast. And there we go. In fact, let me make it a little bit shorter so you guys can paste it in more easily. Do that one there. And that should help. All right, Jesse, thanks for showing up. Get rid of that one there. Oops. Absolutely, guys. You're gonna you'll enjoy the channel, and always plenty of interesting characters there. I've learned a lot with some of the people he's had on there too. And again, it's very open ended, so the guests are allowed to really open up and speak a lot more than they could in any other situation. And on top of it all, I think Jesse's been like shadow banned like 10 times or something like that. So, enjoy it while you can. All right, let's get back to the program. So, the ultimate purposes of the federal rules of evidence are the ascertainment of the truth and the just determination of the proceedings. Wait, we missed this part here. The federal rules of evidence must be construed to secure fairness in administration, elimination of unjustifiable expense and delay, and promotion of growth and development of the law of evidence to the end that the truth may be ascertained and proceedings justly determined. So, again, this is construction. We're looking at the purpose and then the construction. So what is the purpose? To be construed to secure fairness. That's our purpose. In administration. Another purpose is elimination of unjustifiable expense and delay. Unjustifiable. And promote the growth and development of the law of evidence to the end that the truth may be ascertained and proceedings justly determined. High purposes there. The ultimate purposes of the federal rules of evidence are the ascertainment of the truth and the just determination of the proceedings. These purposes are reflected in Rule 401. All right, so these are some of the rules that we'll get into some more details here. I know from the chat here, Pero had mentioned another rule here, 803, which I'm sure we'll get to shortly. So, Rule 401, relating to the definition of relevant evidence. Rule 402, relating to the relevant evidence as generally admissible and irrelevant evidence as inadmissible. Rule 403, relating to the exclusion of relevant evidence on grounds of prejudice, confusion, or waste of time. Again, we're back to the purposes here. Unnecessary or unjustifiable delay. And Rule 501, relating to privileges. Rule 608B, relating to attaching or supporting credibility through intrinsic evidence of specific instances of conduct of a witness. Oh boy. So 608B is relating to or attaching or supporting credibility through extrinsic evidence of specific instances of conduct of a witness. So the conduct of a witness, specific instances of conduct of a witness. And that supports credibility. That's, I guess, outlined in Rule 608B. Rule 609C, relating to impeachment by evidence of a conviction of a crime where there has been a pardon, annulment, or certificate of rehabilitation. Wow. Certificate of rehabilitation. That's a new one. And the one that Pero had mentioned, Rule 803, relating to exceptions to the hearsay rule. In accordance with these purposes, it has been held that the provision prohibiting extrinsic evidence of specific instances of the conduct of a witness for the purpose of attacking or supporting the credibility of a witness other than the conviction of crime as provided in the Rules of Evidence 609 should not be read in isolation, when to do so would destroy the purpose of ascertaining the truth. Wow. Should not be read in isolation because it would destroy the purpose of ascertaining the truth, especially when a witness directly contradicts the relevant evidence which Federal Rules of Evidence seeks to exclude. 608B, that's under the hearsay, exceptions to the hearsay. It has also been held that under the rule, that's capital R rule, providing that, in part, that evidence of a conviction is not admissible if the conviction has been subject of a certificate of rehabilitation or other equivalent procedure based on a finding of the rehabilitation of the person convicted. A trial judge may conclude that a witness has been rehabilitated, even though such rehabilitation is not evidenced by a certificate of any nature. Since the rule permits an exercise of discretion by the trial court in implementing the purpose of the rule, capital R, to the end that truth may be ascertained and proceedings justly determined in accordance with the Federal Rules of Evidence 102. So, a lot there, but what it's stating here is that the certificate of rehabilitation is not totally necessary for a finding of rehabilitation by a trial judge because it's within their discretion of the trial court. Moreover, the trial judge is free to fashion an evidentiary procedure that will secure fairness in administration to the end that the truth will be ascertained and the proceedings justly determined under Federal Rules of Evidence 102, where the Federal Rules of Evidence do not provide a procedure, such as where impeachment of a witness is sought by subsequent inconsistent statements. So this is getting back to what we were reading here before, the development of the law of evidence to the end that the truth may be ascertained and proceedings justly determined. So that's where, when there is no adequate, let's see here, what was the wording they used here? It's free to fashion an evidentiary procedure where it's not provided by the federal rules. Okay, so there it is. So that's one way where it can be developed. Observation. The advisory committee's commentary is particularly relevant in determining the meaning of a federal rule of evidence as enacted by Congress. So the advisory committees is relevant where Congress has not amended the advisory committee's draft of the rule in any way that touches upon the issue in question. So remember, it's particularly relevant, and the advisory committee's commentary will have some weight, but it is not the law itself. All right, let's bounce back over here to the chat. And let me give it a quick refresh here and ensure we're keeping up with everything. All right, we have Jesse says, thanks, Charlie. We have around 50,000 subscribers on our other platform. That's 6 YouTube channels deleted with over 20,000. Yeah, it's. I see you have a lot on the other platforms, but it's so sad to not see so many on YouTube. It's just, guys, you really need to subscribe there and just see. If you don't like it, then unsubscribe. But I think you'd be satisfied because it's. I'd have to say it's the most under promoted channel there on YouTube right now. With the caliber of guests that he has, I just find it amazing he could have just so few people on the YouTube channel. But I understand after having 6 of them banned, then yeah, it's hard to rebuild. All right, let's get here to section 20, the introduction, case authorities. Defendant's statements concerning his accident in reclining chair, made before he died, of unrelated causes, are inadmissible in diversity case, even though state law governs substantive questions, and plaintiff argues that Massachusetts statute making declarations of deceased persons more readily admissible is substantive because rule allowing declarations made in good faith and upon personal knowledge of declarant is mere rule of admissibility, and Federal Rule of Evidence 601 was never intended to give life to it in federal courts. Wow, Donovan versus Sears, Roebuck and Company. Remember them. Accident reclining chair. Before he died of unrelated causes. Interesting case there. 94. Here are practice references. Yeah, nothing else here. Beach aircraft, yikes. All right, here we go. Section 21, securing fairness in administration. The Federal Rules of Evidence shall be construed to secure fairness in administration to the end that the truth may be ascertained and proceedings justly determined. Guys, if you look at this, the end that the truth may be ascertained and proceedings justly determined. Should you ever find yourself in any of these venues, this is a statement here that you could repeat it over and over and over again, and it will always have relevance because this is the foundation of the rules of evidence. This is the purpose. Thus, a trial court may properly exercise its discretion by reason of Federal Rules of Evidence 102 in not rigidly applying in isolation a particular rule, which would obstruct and defeat the central purpose of the rules, capital R, as a whole, which is truth being ascertained and proceedings justly determined. And the court may apply a balancing test of the peculiarities and relevant factors of the individual case. Nice. And here's our practice reference again from Federal Evidence. This is like a favorite textbook here from American Jurisprudence. And let's see here for Rules Evidentiary Service. All right. Yes. This is a good one coming up tomorrow about the deep state and 5G. And the nice thing about Jesse's show is that he takes questions from the chat, which is definitely a unique approach when you're having such a high-level guest on your show. And it really gives a nice interactive element to the show. All right, let's continue here. Section 22, eliminating unjustifiable expense and delay. The Federal Rules of Evidence are to be construed to secure elimination of unjustifiable expense and delay. The rule dealing with the exclusion of relevant evidence on grounds of prejudice, confusion, or waste of time, when read in the light of Federal Rules of Evidence 102, contemplates a flexible scheme of discretionary judgments by trial courts designed to minimize the evidentiary costs of protecting parties from unfair prejudice. Similarly, Federal Rules of Evidence 102, together with the Federal Rules of Evidence 403 and certain rules of the Federal Rules of Civil Procedure, when read with the congressional mandate requiring prompt action on complaints of federal employment discrimination, provides adequate authority for a district court to make a decision summarily upon an administrative record in a federal employment discrimination case, though district court, on a showing of need, should exercise its discretion to reopen the record and hear additional evidence, or permit the plaintiff to proceed to develop additional relevant evidence through discovery procedures. Further, the view that a class action hearing is not accompanied by the traditional rules and procedures applicable to civil trials, even though the Federal Rules of Evidence 1101B provides that the rules, capital R rules, apply generally to civil actions and proceedings, has been held to be consistent with the Federal Rules of Evidence 102's mandate to construe the rules in a manner so as to avoid unjustifiable expense and delay without negatively affecting the just determination of the merits of the case. So, you have to justify expenses and delays. See, our footnotes, of course, are great. Lusel and Mueller Federal Evidence book. I guess if you want to be an expert in federal evidence, this seems like a good book to have. See, stating that exclusion of proof of arrest of a defendant conditioned upon the entry of a stipulation by the defendant that he was in a certain place at a certain time and used a certain false name is justified. Wow, that's an interesting one there. So let's read this thing here and get this, because they really keep this short here when they're giving these footnotes. The exclusion of proof of an arrest of a defendant conditioned upon the entry of a stipulation by the defendant that he was in a certain place at a certain time and uses false name is justified. So exclusion of proof of arrest is justified. Wow. All right. And let's continue on here. Section 23, promotion of growth and development of law. So we're seeing kind of how the judges have the discretion to come up with procedures. The Federal Rules of Evidence are to be construed to secure promotion of the growth and development of the law of evidence. Federal Rules of Evidence were not designed to render the law of evidence intransmutable. Rather, Federal Rules of Evidence 102 is designed to allow expansion of the Federal Rules of Evidence by analogy to cover new or unanticipated situations. Federal Rules of Evidence 102 authorize the court to interpret the Federal Rules of Evidence creatively so as to promote growth and development in the law of evidence in the interest of justice and reliable fact-finding. As a result, a court found support in the rule, capital R for rule, for its conditioning of an advanced ruling on the use of a state felony conviction for assault in impeaching a defendant on barring defense counsel from presenting evidence, though cross-examination or otherwise, of any assault convictions of any of the government's witnesses without specific advance authorization from the court, even though such condition is not specifically authorized by the rule governing impeachment by evidence of a prior criminal conviction, which is designed to protect defendants from unfair prejudice. However, this application of Federal Rules of Evidence 102 has been criticized by another court as a legislative action. Wow. Moreover, because the Federal Rules of Evidence do not provide a procedure for impeachment by subsequent inconsistent statements, the trial judge is free to fashion an evidentiary procedure that will promote growth and development of the law to the end that the truth may be ascertained and proceedings justly determined under Federal Rules of Evidence 102. So we see here that subsequent inconsistent statements, there's no procedure for impeachment. So the judge had to come up with his own, like, one more time and you'll be impeached. That actually probably could have been what it was. All right, now we're on to my very favorite part here. I don't know if we're going to have time for this tonight. Let's see. We're up to the hour mark, so this is a great place to take over next time on judicial notice. Judicial notice is another powerful tool to use in the courts that can be very effective for litigants, but judges just hate it because it just adds more work for them. So we'll get into this one next time. Before we do that, let's jump over here to the chat and see what we got going here. Any other questions, clarifications, experiences like to share? Just make sure we all subscribe to Jesse there with the missing link. Let's see if I can pin that up there. There you go. Have some very thought-provoking guests and conversation, and it goes into a good free-form, long-form interview, which is almost a lost art these days. So I encourage y'all to go there. I always like to try to listen in the background, sometimes during work, and if I have a chance, I always love to interact because it is can be enlightening depending on the guest. With that said, I hope to see you all on the next one. We'll be covering the judicial notice and continuing with law of evidence from American jurisprudence. Salute you all for being here, and I'll see you all on the next one. Peace out.